The state's attorney is criticizing me for not knowing the law. I've been talking about a man who stole 5 cars in 3 months. Each time, the prosecutor asked for very minimal court-ordered conditions of release. I thought better conditions should have been imposed. Now, this defendant's a real person. I don't want people to hate this man, and he's innocent until proven guilty. Regarding the state's attorney's criticisms, I ask you to consider 4 points. The first is what the purposes of conditions of release are. The state's attorney says, quote, "The other condition of release that my opponent said he would have imposed is a responsible adult condition, which is essentially the court's ability to release somebody into the custody of somebody else, again, to mitigate their risk of flight." A few seconds earlier, she said, and again I quote, "If a judge decides that conditions of release are appropriate, it's up to them to impose the conditions that are the least restrictive to mitigate that person's risk of flight from prosecution. That's the law," end quote. Well, that's not the whole law because it only talks about risk of flight and entirely omits the law's next paragraph, the part that deals with public safety. The law's citation is 13 Vermont Statutes Annotated, section 7554. Subsection A1 does talk about court-ordered conditions to reduce the risk the defendant will flee. But subsection A2, not mentioned by the state's attorney, authorizes the judge to issue other orders to reasonably protect the public. That fact matters. Second, this defendant had multiple pending felonies before he allegedly stole 5 cars in 3 months. He was allegedly awaiting trial for allegedly stealing $41,000 from an armored car, an earlier alleged car theft where he allegedly found the car's owner's checkbook, forged her name and cashed her checks, and numerous retail thefts. But the state's attorney says even asking for a curfew would be unfair because the defendant is homeless. What was not said is that a judge had imposed a curfew on this defendant just a month before he was arrested this last time. What was not said was that the state's attorney is prosecuting him for the crime of violating this curfew condition. So she's criticizing me as being unfair for suggesting a curfew condition at the same time she's prosecuting the defendant for violating a curfew condition. Does that fact matter? Third, the state's attorney said that a condition of release that holds the defendant in custody until a responsible adult can supervise him, in the name of public safety, isn't legally allowed because he's only charged with nonviolent crimes. What she doesn't say is the judge actually did order him to be held in custody until a responsible adult can supervise him in the most recent case. The state's attorney did not object, and the state's attorney has not asked the judge to free him from this so-called illegal incarceration. Does that fact matter? Fourth, a legitimate criticism was made about how I said things in my original video. Only the judge has the power to impose conditions of release. My phrasing combined the role of prosecutor and judge, and I'm sorry for that. A prosecutor's job is to advocate for conditions of release that will reduce the risk of the defendant fleeing and keep the community safe. If you're curious, I believe that asking a defendant accused of stealing tens of thousands of dollars from an armored car, forging a woman's signature on her stolen checks, committing serial retail theft, and stealing 5 different people's cars in the span of 3 months should either be held in jail until trial or given very firm conditions of release. This is not cruel. This is firm, but it's fair. Thank you for your time.